Good morning, Your Honors. May it please the Court, Jim Amberg on behalf of Ms. Vanderburg. I know that both people and I have extensively briefed the facts in this case, which I think are more important in this case than normal in other types of cases. I'd like to just reiterate a few things about what the lower court, the trial court, finds when they quash this case. And that is, when you look at this particular situation where we have a 79-year-old great-grandmother who is thrown into this chaotic situation, who had nothing to do with what happened. And then all of a sudden, out of the blue, you have a police officer trying to arrest her grandson. What the lower court, I think, really hung their hat on, was the touching that took place in this case. It's very clear from my reading of the transcript and my understanding of the case that Ms. Vanderburg didn't go over there and try to stop this officer. She tried to communicate with this officer. Here she is, and I don't know how anybody can possibly react any differently. This is an absolute chaotic situation. We have an officer who, probably should have had other officers there, or maybe should have been a little more cautious. I think the officer even admits that he had some fear while he was there.
How soon after the, quote, tasering, did the backup officers appear on the scene?
I'm not sure exactly, Your Honor. I do know that they ended up arriving. Once the officer who did the pepper spraying of Ms. Vanderburg arrived, I think around that time is when he actually physically calls for other officers for backup. The way I read that transcript, I wasn't there at the preliminary examination, but the way I read the transcript, that's what happens. So then we have other officers arrive. So really, we have this situation where we have a lone officer, and we have this suspect that he's trying to arrest, and then you throw Ms. Vanderburg in the middle of this. And that's the big problem here, is that what the officer did was he pepper sprayed her, and all she wanted to do was, at the very most, talk to him. She was extremely confused. I think that the officer at first testified, or at least it was alluded that she pushed him back. I somewhat take offense to that, having met Ms. Vanderburg, and I know this is sort of outside of the transcript, but this is a 79-year-old, frail great-grandmother. This officer is a strong young man about twice her size. I think Judge Botzer, the circuit court judge, recognized that in his opinion, and I think he made an honest opinion. I know that it's easy when we look at these real broad statutes like resisting arrest. That's a real broad statute. It's really easy to take a set of facts and just put them in there. But I believe that the law, a lot of the times, is really about common sense. And this is a common sense case. We have a 79-year-old great-grandmother who was minding her own business, who had no idea what was going on. She gets thrown into this absolute chaotic situation that was at least partially caused by the officer.
That's where you get into a problem. Now, Judge Botzer, who is the circuit judge,
Yes.
is not usually known as a flaming liberal, okay? And somewhat conservative. And he throws this thing out saying, I don't believe it belongs up here or whatever. Now, the problem you got in this case, though, here comes your client out, charging out and reacting because her grandson is being hauled away or whatever. This could have developed into a dangerous situation with the officer if it's that chaotic with someone grabbing for a gun or whatever. Correct, Counselor? Could that have happened?
I think that, Your Honor, anything could have happened. And I understand. I think Judge Botzer, when you look at his opinion and what he talks about in his oral opinion, I think he sort of touches on that. And he recognizes that the officer is afraid because, we do have an officer that's thrown into a situation. I'm not saying he's fully responsible. The grandson leads this officer to his grandmother's house.
So I think, personally, I'm not speaking for the other judges here, but I'm thinking it certainly was an overcharge here. And if anything, there should have been a disorderly conduct charge or whatever. And I think Judge Botzer, in his opinion, mentioned, did he not, something about protection for a civil suit or whatever? Or am I?
Well, that was, now, and I wasn't there. It was my partner, Jesse Williams, who did the exam and then argued the motion in front of Judge Botzer. And I think Mr. Williams indicated that the chief of police had indicated to him that the the case couldn't be dismissed because, you know, Ms. Vanderburg was going to sue the police department because she had been injured by the pepper spray. And so that's what they were talking about. I don't think that was outcome determinative of what Judge Botzer does. I think Judge Botzer, as he's going through this and throwing all these factors in there, considering the fact that, yes, this is a major overcharge, you know, these resisting felonies, a 2-year felony, should be limited to something that's an actual felony. You punch a police officer. Oh yeah, 2-year felony, right there.
Counsel, you would acknowledge, would you not, though, the decision as to what charge to bring is with the prosecutor, not with the judge?
I absolutely agree, Your Honor. And regarding that issue, I don't believe that Judge Botzer usurped the people. The people can bring whatever charges they want. However, we do have these mechanisms in place to protect the civilians of Michigan from things like 79-year-old great-grandmothers being charged with felony cases when it's not a felony case.
Well, one of the problems you have here too, Counselor, though, is that the district court bound this case over. That's why it's in circuit. That's why it eventually gets quashed. That's a problem you got, and you go way back to the 70s. I hate to say that I was somewhat involved in this Genesee County prosecutors circuit court case going back, saying bluntly that the prosecutor can charge what he wants to do. And the problem you got here is that the district court bound this over.
And Your Honor, as a lawyer who, you know, although I do appellate cases, my main practice is criminal defense at the trial level.
I did it for 25 years. All over this day.
And the way I look at it is I file a lot of motions to quash. I think that sometimes the district court will get it wrong, and we have this mechanism here for the circuit court to correct that problem. That happened in this case, and you know, that's why we have it. It's because Judge Botzer, and as Your Honor points out, a learned judge who used
Very good judge.
Very good judge, yes.
Sat up here when we were having circuit judges join us with our docket.
And a very, I think, an intellectual judge too, when he looks at the law. And I think he looked at this case, and because from what I recall about the case laws, these cases are done on a case-by-case basis. So we're looking at the facts of each case when we're determining whether or not this should have been bound or should have been quashed. And I think Judge Botzer did that. He looked at it and took a fair look at this case and the facts from the exam and said this is not a felony. I don't think he was trying to usurp the people and say, well, you shouldn't be charging that. He said that. He made a suggestion maybe they shouldn't, but I don't believe for a second that he was trying to overpower them. He just felt that it wasn't a felony.
Counsel, the charge is resisting or obstructing a police officer. And the officer testified at the exam that Mrs. Vanderburg, I'm quoting his testimony here, came around in front of me waving her hands again. I said, you need to back up. She proceeded to come to me, put her hands on my chest and my arm, pushing me back. I shoved back, said, get back. And at this time, I could see the other suspect with the tattoos, and that's the grandson, coming towards me. So now I had 2 people coming at me. Now that's a chaotic situation for a police officer. But based upon that testimony alone, isn't that sufficient for this to proceed and let a jury make a determination?
If you look solely at that testimony, where it appears from the testimony of Officer Wolf that Ms. Vanderburg somehow pushes this officer back.
He testified she did.
At first he does testify that she does, but then as you go on later on into the transcript, I believe that he then sort of backsteps from that statement and says, well, I don't know, and I'm looking for the line, it looks like page 37, 14 through 17 of the transcript, and I put it in my brief. Specifically in response, and this is just from my brief, I'm not quoting it directly from the transcript. Specifically in response to the question of how much force did Ms. Vanderburg use to push him back, he responded by indicating he did not know. Okay, page 36, line 21 and 22. And now Judge Botzer, when you look at how he holds in his oral opinion, he's looking at that statement too. And when you read the end of that opinion, and I think I might have put that in my brief, actually cut that out from what he says, but he makes reference to that too, where he's saying, well, wait a second, this officer said one thing, and now, you know, he doesn't know if he was step back. What Judge Botzer really says, and this is what he puts down in his, when he's on the record making his opinion, is that he finds that the officer was startled. And I don't think anybody would disagree. He's already upset. I'm not a police officer. I don't know. I would imagine it's probably a pretty scary situation. You've got this guy who had pulled over. But when Miss Vanderburg comes up and puts her hands on him, it's not to block him like a football player. It's to communicate with him. Please, what's going on? I don't understand.
Well, that's your supposition of what was going on, but I just quoted the officer's testimony, and I'm just asking, just quite bluntly, isn't that sufficient for this to be bound over and proceed to trial? And your response apparently is no.
Your time is almost up, Counselor, and quite frankly, I'm the only one judge. I don't know where this thing is, what I'm going to do on this thing, but Judge Murphy's got the point. The case has been bound over. There's testimony. We're going to go to a jury. Judge Botzer sees this thing and he says, look, I covered 3 counties or whatever it is. I don't want this junk in front of me. This doesn't belong here, okay, in front of a jury trial. I'm not sure the jury will be out very long on something like this. But quite frankly, our job is to look at the law. And the problem you've got is the district court found this thing over.
And Your Honor, I do understand that.
I think we pretty well understand the case, Counsel.
I know, and I feel like I'm reiterating it, but I do, Your Honor, I do want.
Time is up, so
Thank you, Your Honor. Thank you, Your Honor.
the case is